The Interim Joint Committee on Judiciary. This will be our first meeting of obviously myself and Chairman Westerfield will rotate these meetings. We've planned that out, so you'll have him next month, and I'm sure it'll be as full as the agenda is today. With that being said, I'm going to ask everyone to silence their cell phones or put them so that they're on vibrate mode so that we don't get disturbed or have interference. And then I'll ask all presenters when they come today to remind themselves to make sure the mic is on with the green light, because we try to pick that up for purposes of recording. With that, Madam Secretary, please call the roll.
Senator Berg. Senator Carroll.
Here.
Senator Kerr. Senator Neal. Senator Schickel. Senator Schroeder. Senator Stivers. Senator Turner.
Here.
Senator West. Senator Wheeler. Representative Banta.
Here.
Representative Blanton.
Here.
Representative Bratcher. Representative Cantrell. Representative Decker. Representative Elliott.
Here.
Representative Fisher.
Here.
Representative Heverin.
Present.
Representative Colcarney.
Present.
Representative Lewis.
Here.
Representative Maddox.
Here.
Representative McCoy.
Here.
Representative Minter.
Here.
Representative Mosier. Representative Nemes. Representative Petrie.
Here.
Representative Scott. Representative Stevenson. Senator Westerfield.
Here.
Chairman Massey.
Here. Well, thank you everyone for attending. We're going to go one item out of order today because we have a couple of things going on. Judge Goodman, who is going to be with us for the persistent felony offender matter, is in docket right now, and she should be free by 11:30. So therefore, we're going to proceed with the item number 4 on the agenda, which is Tennessee General Assembly House Bill 1834, Vehicular Homicide due to Intoxication. We have with us by Zoom today Representative Mark Hall, Tennessee House District 24. I talked with him this morning on my way in. He is finishing up his 4th year in the Tennessee General Assembly. He is currently running for the Tennessee Senate, and he was the sponsor of this bill. So we've asked him to bring it forward for us for purposes of discussion. And so that you know, we had seen some press coverage on this. I did not know that 14 states, I think, or something of that effect he mentioned, have taken up this issue. I don't know how many have carried it across the finish line, but he will talk about his experience in Tennessee. So with that, I'm going to introduce Mr. Mark Hall, representative from Tennessee House District 64. Mr. Hall? Are you there? I think that's him. Mr. Hall? I can call him. He's going to try it again. Are you there?
Can you hear me?
We can hear you now.
Yes, sir.
All right. I already gave you a glorious introduction, so I'm not going to repeat that. We're just going to go right into it. They know vaguely who you are, and I'll let you introduce yourself and go ahead and tell us about House Bill 1834 from the Tennessee General Assembly.
Thank you. Yes, I'm State Representative Mark Hall from the great state of Tennessee. I represent Cleveland and Bradley County. We're referring to what we call as Bentley's Law, and it is regarding basically if a parent of a minor child died at the hands of a drunk driver, the drunk driver would then be responsible for child support. It does two things. It protects our greatest resource, which is our children, and also holds the drunk driver accountable. 14 other states have taken a step in this direction. I'm not real sure how many has crossed the finish line with it, but the great state of Tennessee was first, and it gives us something to build on. This is just another tool in the toolbox to move the needle in a positive direction for addressing DUIs.
We would very much like to know how the process went in the Tennessee General Assembly, what kind of debate you had about it, what kind of resistance you may have had, et cetera, what kind of groups were in support, maybe against, and, talk about that with us so we could, discuss this among ourselves and decide if it's something this body would like to do.
Well, once I introduced the bill and it started making its way through the committee process, it really started picking up some momentum and building a lot of support behind it. So I felt like that we had something good. It was, it had never been tried before. It was a very common sense approach and very straightforward. So this was very foreign to us because, it was just I felt like that it was a great bill. I felt like that it was going to pass, but I didn't know what kind of pushback or resistance that it was going to have as it made its way through the committee process. But it passed unanimously. As the further it went in the committee process, the stronger the bill became. So I knew we had enough support to cross the finish line with it.
Did you run into any resistance in the Senate?
Maybe a few questions and maybe a little bit of pushback, but it was it was sort of a no-brainer for us. In the great state of Tennessee, if you were to get a DUI today, you would only have a 17% chance of getting a second. But if you had a second, you'd have a 70% chance of getting a third. So this was just one tool. We didn't know, what kind of effect long-term that it would have, but we felt like that this was one tool in the toolbox that was going to make a difference in our state. So I felt good about it. Very little pushback as it started making its way through the committee process. It became stronger and stronger, and a lot more support behind it.
With regards to that, is there obviously, depending on the person, obviously maybe incarcerated, et cetera, may not have any financials to do that. So it could be, some could say it's an empty shell, but is there like a restitution order that would go with that, or can you tell us that?
Well, I left it open-ended on purpose for the simple fact I wanted to take the shackles off of the DA and the judges to allow them to use their own discretion. It's my belief that there will be a formula in place, almost like a divorce settlement agreement, to where, depending on the needs of the child and the income of the offender, it would sort of be set in place to what they owe. And of course, the payments doesn't start until 1 year after they are released from incarceration. So I felt like that it was important that we had this law in place. It gives us something to build off of, and I'm anticipating that it's going to be amended and tweaked along the way to even make it stronger in the future.
All right, we do have a few questions. I'm not going to dominate this. We're going to turn it over to our Senate President, President Stivers.
Thank you, Mr. Chair. I want to understand, this would be child support where a parent has been killed but no obligation order entered, or there has been a child support order entered?
I think I could probably help you with that question, or help you understand it from my perspective. If it's a family that's doing well, and husband and wife, whatever, there's no child support order, it's just a good family situation, then if one of the parents is killed, then there would be an obligation by the offender to pay child support under your law. On the other hand, if there was a situation where there was already an order of support, it would almost be that the person would replace that person already paying support.
As the obligor.
The obligor. And so that, maybe that's why you left it open-ended, so that could be merited out or dealt with through the prosecuting attorney.
Yes, sir, that is correct. And the bill was left open-ended on purpose to allow the judge to maneuver through the maze of craziness, and it allows it takes the shackles off of the judges and allow them to use their own discretion. So that was by design. I wanted to make sure that the main thing, a lot of people think that this bill was drafted to punish, DUI offenders, and it was, but more importantly, it was to protect our children. So I'm anticipating there'll be in the future there's going to be a formula in place, just like a divorce settlement agreement, that that each case would be totally different, but the formula would remain the same.
All right, I want to return to President Stivers to see if
Just a quick follow-up. So as I understand this, you're envisioning some type of potential offset if there were litigation in a wrongful death case, which that's what we term it here. And I'm not saying I'm for or against it. I'm just trying to understand the mechanics of it. Would there be an offset that if there was a wrongful death action that that would offset some of the child support obligation or not? Is that to be factored in it, or is this still kind of how you're leaving it to the discretion of the court to factor in what may come into play into an overall calculation?
Mr. Chairman, I can just barely hear the audio, and my apologies. But I think he's asking about the offset between the civil judgment and the child support. If
That's correct.
I hope I'm just getting bits and pieces of it.
that is correct.
But yeah, it's at the sole discretion of the courts to determine that, and it would certainly be an offset. It's like
Interesting concept.
I lost you there. It would be a even though whether the offender paid or not, he would still owe. So it's and it would be impossible to. It'd be like a school loan. It was some people don't pay, but it doesn't mean that they still don't owe it. So it would be set in place. It would never go away, and it would be due 1 year after the offender was released from incarceration.
Thank you. Senator Turner.
Thank you for being here this morning, and I have a follow-up. So, to kind of up on our previous question, Tennessee mandates insurance coverage like Kentucky does, as I understand it. So, there would be a offset for the funds that would be paid from the insurance. Everybody's mandated to carry insurance, as I would understand what you just said. But what if there's such things as Social Security or other benefits that child ends up receiving? Would there be offsets for that, or is it just going to be mandatory that everybody's in a case where there's a wrongful death action by child support, as you're now saying this statute requires, that there's going to be mandatory payments irrespective of the amount the child should get from other funds?
Thank you for the question. It's my belief that this is the sole discretion of the courts. It is solely left up to the judge to determine that. Based on the needs of the child and the ability to pay of the offender, and the income flow of the offender. So with more needs if a child has more needs, or if there's any kind of special circumstances involved there, then that would be adjusted solely by the court. This isn't a one size fits all. And so that's why it's important that the bill be left open-ended to give the discretion to the judge. Anything less than that would be a disservice to the children.
Senator Berg.
Thank you, Mr. Chairman. I think my question goes to what happens when you have a defendant who has killed a parent, has been found guilty, has served his time, gets discharged, now has this obligation for child support, and they can't meet that obligation. Is that a criminal offense at this point? They go back to jail? Or what happens in that situation? Because my concern then is that we're basically jailing people who have less money and not jailing people who can afford this verdict.
Great question, and I hope I heard you right. But the inability to pay or the non-payment doesn't mean that the offender doesn't owe it. So, it is, and you can't bankrupt out of child support. The same formula would be in place for those that are the offender, as if they were involved in a divorce settlement agreement. So just because they don't pay, it's like some people don't pay child support, it doesn't mean that they don't owe it. So it would never go away. So they would still owe it, and it could be adjusted through garnishments or liens or anything like that. So I'm not real sure how the great state of Kentucky does it, but in Tennessee, it would still never go away just because they didn't pay it.
Follow up.
Yes.
But
Yes.
You don't get incarcerated for not paying?
That would be the sole discretion of the judge. Just like some people get incarcerated for not paying child support, and some people do not. Each case would be different.
Thank you.
And Senator, based on the law we passed a session ago, if it went over 5,000 and it was a contemptible arrearage, then they could be put in jail. If it's a non-contemptible arrearage, which means it accrued while they were incarcerated, that wouldn't trigger that. But if they got out and then didn't pay, then foreseeably it could wind up being another offense, at least in Kentucky. Any other questions? Representative, thank you for being with us today. I would have loved to have had you in person, but I understand that we are probably in the busiest month of the year for vacations and families and things like that. So we thank you for taking out of your busy schedule, your campaign schedule, and to talk with us today. We may be reaching out to you for more information if someone from this body would like to proceed or consider drafting a piece of this legislation. So thank you for your time.
Hey, thank you very much. Thank you for having me.
Have a great day, sir.
Thank you. God bless you.
With that, we're going to go right into our second item and follow the agenda here on out, and we're going to talk about KRS 532080, persistent felony offenders. So we're going to ask the group. We have several people here. We have Commonwealth Attorney Rob Sanders, DPA Scott West, DPA Ashley Graham, and Marcus Jackson from the ASOU to come on forward. And I believe Judge Goodman, we're going to reach out to her and see if she should be becoming available in the next 5 to 10 minutes. So with that, if those that are here could come forward. Come on up, Rob, if you don't mind. And while they're coming up, let me tell you why we're having this on the agenda. We started a work group on this particular topic because we might need to pull another chair over for somebody. There's 3 there, and Judge Goodman will be by Zoom. We started an informal work group that basically we're talking about the effects of PFO. This came out of a couple of circumstances we had heard about, one in which I was involved in, where a PFO had been assigned to a particular is a charge to a defendant in that particular area or region. I was told by one of the assistant Commonwealth attorneys that once a PFO is charged, it's not removed unless the judge sees otherwise. And so we ultimately resolved that case. But the long story short is there seems to be some inconsistencies with PFOs, how they're used, and how it affects different defendants over different ways. So one of the things that came up in that discussion, this is why I brought experts in here to talk about it, is that PFOs obviously can be levied when there's been a prior felony offense attributed to a defendant. It obviously can give you mandatory jail time if you're convicted of that PFO, which is why, from a defense perspective at least, a lot of people feel like, well, I can't even risk going to trial even if I wanted to go to trial because of the impact of a PFO being placed upon me. On the other hand, you can have somebody that has a long gap between when they got their felony and when they picked up a second felony to get a PFO, and in some ways they get treated differently. So I've got both perspectives here today. We have Commonwealth Attorney Rob Sanders, who has done a very good job for the people of Kentucky and the Commonwealth by virtue of being the Commonwealth Attorney in Kenton County. He's been on a number of task forces, different things. He's basically been very involved in the implementation of policy around things involving prosecution and defense. We have, of course, the DPA with us here today that handle a lot of these cases. And then we have Mr. Jackson from the ACLU. So I don't know who wants to begin. I know that we're going to reach out. I'm going to text Judge Goodman to try to get her on here as soon as we can. She's going to give a judicial perspective, but we want to have that discussion here today. So with that, I kind of know how each person up there already feels, but we're going to let you give your overview of it if you don't mind. I think I would like to actually go out a little bit on that, maybe start with Mr. Jackson. I think he talked to us before at the meeting, and have him kind of lead into the discussion, and then we'll go from there. So Mr. Jackson.
Can you hear me?
We can hear you now.
Perfect. Chairman Massey and Westerfield, members of the Interim Joint Judiciary Committee, good morning. I am Marcus Jackson, the Smart Justice Organizing Coordinator with the ACLU of Kentucky and facilitator of the Smart Justice Advocates, a group of directly impacted people working boldly to inspire change through policy, legislation, community engagements.
Can you pull that closer to you? It's still breaking up a little bit.
How about now?
That's better.
All right. It's an honor to have the opportunity to speak with you today about Kentucky's Pfo Law. Not as a lawyer, but as a father sentenced to Pfo and the son of a father sentenced to Pfo. I urge you to restore judicial discretion to the law by removing the language prohibiting probation, shock probation, and conditional discharge for nonviolent, non-Class D offenders, and to end mandatory minimums for nonviolent, non-Class D offenders sentenced to first-degree Pfo. Some of you have seen the documentary Persistent or know my story. My parents are Carolyn and Gary Jackson Sr. And like a lot of Kentuckians, my father struggles and continues to struggle with substance use disorder. My father's illness emerged after an on-the-job accident while working as a mechanic for the city of Paducah. His addiction impacted our family in a lot of ways, but mostly it taught us what it was like to be poor. In spite of the hardships of our families faced, hardships lots of Kentuckians face, we make it. Turned out I was a decent athlete. As my mom said in the documentary, all I wanted to do was be with family and do my sports. And that was a pretty fair assessment. Even though I had planned to stay close to home and attend Mary State University, I got recruited to the best football team in the state, my father's favorite school, the University of Louisville, where I was part of the 1990-91 Fiesta Bowl winning team. Life was good. I returned Paducah, a hometown celebrity and high on life. Then in March of 1992, I was sentenced to 5 years in prison. I was terrified, but eventually I adapted. Prison became my institution of higher learning. Part fear, part desperation. I listened to the prison professors who educated me on how the criminal legal system was stacked against me. I learned how to survive in an environment that was meant to destroy me. And I was released with a new perspective on life. I returned home a shell of the person I was before. I could not return to school, and my dreams of becoming a professional football player were over. Everything I knew had been taken from me. I was lost. I did not want to return to prison, but I was no longer afraid to go to prison. You can only scare a person with prison once. By the time I was 24, I had a total of 25 years, 20 of which were second-degree PFO. And by the time I turned 36, I had a total of 40 years, 15 of which was for first-degree PFO and required me to serve a mandatory 10-year sentence. I had to serve 6 years behind the fence before I could receive minimum custody. So I was sent to Kentucky State Penitentiary, the only maximum security prison in the Commonwealth, and I was convicted of marijuana. I was trapped in the revolving doors of incarceration and didn't know how to end the vicious cycle. A couple of things occurred which changed the trajectory of my life. The first, I received affidavits from the individuals responsible for the crimes that I was convicted in 1992. It was like a weight was lifted off my shoulders. Finally, someone was validating what I had been saying my entire life. The next was my grandmother. She came to visit me at Kentucky State Penitentiary. My grandma, she knew she was the last time she was going to see me. She was sick. I didn't know she was sick. And she didn't tell me she was sick, but I never got a chance to see my grandmother again in this world. The images and words that stick with me to this day. We were sitting in a little visitation table. She reached across and grabbed my hand and told me, never let what others think of you dictate what you think of yourself. And it changed me. If you've seen the documentary, you've seen the toll that the law has taken on my family. And we're not different from other families in Kentucky that have been impacted by substance use disorder, the revolving doors of incarceration, and/or PFO. The current law places any consideration solely in the hands of the Commonwealth attorney. He determines whether I was charged as a persistent felony, and once the indictments were returned, he alone determined if the judge would be able to consider leniency in the form of probation or shock probation by either dismissing the PFO or forcing me to plead guilty under the Pfo Law. This is the unfortunate reality of Kentucky's versions of the two strikes law. Commonwealth attorneys are empowered to create different strike zones for different hitters with impunity and absent judicial safeguards. Please restore judicial discretion to the law by removing the language prohibiting probation, shock probation, and conditional discharge for nonviolent non-Class D offenders, and end mandatory minimums for nonviolent non-Class D offenders sentenced as first-degree persistent felony offenders. Thank you.
Thank you, sir. Glad that you've turned things around. We may have some questions here specifically about the matter going forward, as I know that there's many people on this panel here today, but not all of them practice in this arena, and so they may have some questions about that. So we will circle back around once we've had the presenters fulfill their testimony. So I don't care who goes next, whether it's DPA or Commonwealth Attorney Sanders, doesn't matter. Got a preference? I guess we'll have Mr. West.
Your Honor, I would just move that the prosecution be required to go first since they have the burden.
I'm not Your Honor, but I don't think Rob ever has trouble speaking out at any time. So, Commonwealth Attorney, we'll let you give some comments about PFOs, what your experience has been, and what your thoughts are regarding this matter.
Thank you, Mr. Chairman. I actually don't have anything to present other than don't mess this up. The PFO law works. Commonwealth attorneys use prosecutorial discretion. Sorry, you get feedback from this computer here, so it's really difficult to speak to you and hear myself coming right back at me just a few seconds later. Anyhow, it works. Not everyone is charged with the PFO, even though many more are eligible. We use our discretion to punish the repeat offenders that need to be punished, that need to stop, that need our help to be sat out for a period of time to where they actually serve a legitimate prison sentence and are there long enough to know that they don't want to come back. Because, felonies, it's not a speeding ticket. We're not talking about jaywalking or a dime bag of marijuana. You actually have to do something very significant to get a felony. And if you don't think a Class D felony is significant, then change the law and make whatever that offense is not a Class D felony. You all make the laws. We only enforce the laws. But what we do is try and use the PFO law to stop repeat offenders. We try to sit people out long enough that they hit what I like to call criminal menopause. They are incarcerated long enough that they know they don't want to come back and they stop their criminal behavior. Sorry. The echo here is very difficult. It's back? I'm not sure. I'll try it. Thank you. Anyhow, I think some of the suggestions, I've thought about a lot of them. I've read most of the things that I already tried muting it.
Yeah, we're gonna have to get Tech up here.
I've read a lot of these suggestions, and I've thought about a lot of them, and some of them in some ways make sense, but you think about the implications of the practical effect they'll have on the judicial system, and there's many reasons they just won't work. You have to keep in mind the effective reality of our judicial system and what some of these changes would make, the confusion they would cause. In many examples, I think would cause it to actually be harder for defense attorneys to do their job if they can't reasonably predict to their client what kind of time they're facing. If they're trying to tell a client, well, we go to trial, you could get 1 year in prison, but you could get 20 years in prison. We just don't know. I don't know that that helps the client. I don't know that it helps the defense attorney. This law, I realize that it is applied differently depending on what the local prosecutor feels and how they make their prosecutorial decisions. You have to be very careful if you want to mandate a way that PFO is implemented so that there is no local control or local discretion. It could have very unintended consequences. You could end up with prosecutors sending far more people to prison than we currently do, giving less people probation or diversion for offenses. It could end up in different outcomes for criminals with the same history that commit the same crime, depending on who they are, how they look, things that shouldn't make a difference in what kind of sentence is imposed. I would just urge you all to communicate with Commonwealth attorneys. Anything that you're considering in terms of changes, please let us know. So we're willing to consider anything, but most importantly, we don't want you to break the system. I think that the public, the citizens of Kentucky are tired of criminals. We're seeing that all across the nation. For the most part, we don't have a lot of the problems they're seeing in the big cities. We're not seeing the same thing here. Thank you. Appreciate. Oh, much better. Thank you. We're not seeing a lot of those problems in Kentucky, although we are not totally free of those problems either. And the citizens of Kentucky don't want those problems in the Commonwealth. We don't want to be San Francisco or Los Angeles or New York City. We're doing a very good job. Our justice system, although it has its frustrations it does work. You know, I was talking to my cohort Chris Coron, the Commonwealth's attorney from Warren County, back there earlier today, and he told me that, you know, Rob, the most common question I get when I present PFOs to my grand jury for indictment is, how is this person even out of prison? How are they, you know, I get it, they're eligible for PFO, but you do the numbers. Okay, they got a 5-year sentence in 2018. They got a 2-year sentence in 2020. Now they're back in 2022. How is this possible that this person's out walking the street? Well, it's because our sentencing laws in Kentucky for nonviolent offenses are a joke. The truth in sentencing, people are serving out nonviolent offenses, and about 50% of what their sentence is. So anytime, and I'm not talking about violent offenses. That's a whole nother subject that I could get on a soapbox for, about what's violent in Kentucky and what's not for parole eligibility purposes, because there's lots of violent offenses that are nonviolent for parole purposes. But when we talk about nonviolent offenses, which does include many violent crimes that are classified as nonviolent, you got to remember that when you look on a piece of paper and see Class B felony is 10 to 20 years, when you start counting up all the good time, divide it by 2. Because that's what a serve out is on them. They're serving out 10-year sentences in 5, 20-year sentences in 10, 5-year sentences in a little over 2. You know, and it's very frustrating for Commonwealth attorneys to try and explain all this to our grand juries, to our citizens, to the victims of crime. You know, we are passing laws like Marcy's Law, which does a lot of very good things to help victims of crime, but at the same time, we're turning around and telling them that sentences that are imposed don't mean what the number says, and that we can't, you know, if a lot of these changes were to be implemented, that the punishment for repeat offenders would not be increased. That's not the kind of things the Commonwealth of Kentucky needs. It's not what our citizens want to hear. So, Chairman, I don't have any proposals for you other than the fact that we want to be heard on anything that this body intends to take up.
Well, I will commit to you as long as at least I'm here through the year, so that as we continue to work with this group, that's why we wanted you at the table, so that we would have that input from all people, all stakeholders with respect to this. I think one of the things that we've tried to wrestle with as a Judiciary Committee is also the large number of people that are incarcerated in Kentucky, maybe justifiably so. But I heard a commentary on a radio show the other day that if Kentucky were a country, we would be 7th on the list of how many people we incarcerate in the nation or in the world. I don't know the answer to that. Hopefully, Senate Bill 90, that was the initiative of President Stivers and Chairman Westerfield, will help deal with some of those things going forward. But that's just something that we are trying to consider as well. We do have with us now Judge Goodman. So, Judge, if you're there, I don't know how much you've heard. We have had a presentation from Mr. Jackson from the ACLU of Kentucky, from Commonwealth Attorney Rob Sanders. We have not heard from DPA yet, but if you're on there, we'd love to hear from you.
Can you see me?
We can now.
All right, and obviously you can hear me.
Yes.
Yes, this is Judge Julie Goodman. I am a circuit judge in Fayette County. I'll give you a little bit of background. Prior to taking the bench in circuit, I actually was a district judge for 12 years. So I believe I have a really good grasp of our community, which is one of the larger communities in our state. Additionally, prior to that, I practiced for 28 years, but of those 28 years, 6, I was a prosecutor, starting out as a special prosecutor at the Attorney General's office. And then also I was an assistant Commonwealth attorney. So I think I have a good grasp or understanding of our criminal system. But what it concerns me as a judge, and I actually just got off the bench from doing my criminal docket. I do it every week. There are 5 of us here. We have our dockets are normal. I had 85 on my criminal docket. Of those 85, I would say 70% are there because the individual is either has a drug issue, and the charges are a possession charge or a trafficking charge that usually gets amended down to a possession charge. There are crimes that have occurred because they're homeless, they're mentally ill. These are the issues that we have that cause our dockets to be that high every week of this year and every year hereafter. Our dockets are becoming larger and larger. The concern this court has is, other than the first degree possession charge, Any other drug charge, automatically, if they already have a felony, this Commonwealth Attorney's Office adds a PFO to everything. If you have a prior felony, you get the PFO added. That then creates a situation where individuals are placed in a position that they can't afford to try their cases, because for what are really drug problems or their mental health problems, they can't even run the risk of going to trial because they're facing the PFO. The court feels very strongly that we need stronger parameters on how long a PFO can last on the books. The other problem we see at Fayette County is so many of our flagrant non-supports. And for some odd reason, we have a large amount of flagrant non-supports. They're always probated because we all believe the goal is to have money paid to the children. And therefore, you don't want them in jail, you want them probated. They're usually probated for 5 years, but a condition is always restitution. Well, when they have $30,000 and $40,000 worth of restitution to make, they never get off probation. So then they come along and they get a hiccup and they do something else, and all of a sudden they're facing a PFO. Because even though they've been on, their PFO should have been, they should have been dropped off 10 years ago or 20 years ago, they're still on probation. And because they're still on probation, that flagrant non-support, which they pled to 10 or 12 years ago, is still used against them for another PFO. I think, and I understand what the Commonwealth's attorneys say. I know that they are very concerned about our crime. They are no more concerned than the judges. And let's not forget, the judges get blamed for everything. So if somebody gets out and they commit another crime, it's the judge whose name is called out, not the Commonwealth attorney. And understanding that, I still believe that the PFO is being abused across the state because it is not meant for every type of crime. But yet here, it doesn't matter what the crime is that they've committed. If it's and unfortunately in this county, if you have shoplifted and you get a letter from Walmart that says that you can't come on their property anymore, but then you go back 2 years later, 3 years later, and you shoplift and you take more than you take a felony amount, they don't charge you with criminal trespass and theft by unlawful taking. They charge you with burglary, 1 to 5 in the penitentiary. And then if you've already had a felony, they add a PFO. So basically, I have had, you cannot imagine the number of cases I have had where someone has come in and been charged with a burglary on an actual shoplifting charge and are facing a PFO. And the majority of them are homeless and they're drug addicts. So the court is asking or saying, can we not create some parameters? And we're seeing people that have to stay on probation for longer than they should have because of the restitution issues. Because once they're a felon, they can't get a job anyway, they can't pay their restitution off, so they stay on probation forever. Can we not change it to where the PFO, I believe now it stays on it can be used against you for 5 years, but that's after you get off of probation. Well, if you never get off of probation, it doesn't matter if that PFO was, if that original charge that you're using against them was 10 years ago, 15 years ago. I have a case now where, because the person never got off of probation because of restitution, the charge that they're using against him was in 2001 to put a PFO on him. Can you not change the parameters even of the PFO to say from the date of sentencing, not from the date restitution is paid, not from the date they get off probation, from the date of sentencing? It then protects those people who are flagrant non-supports and will be on probation until the day they die. These are the type of things. And and you do the possession, you can't enhance a possession charge first offense, but you can then take it and use it to turn around and enhance another charge. Could you not look at the drug charges and somehow take them out of the PFO ability to be enhanced? Or look at and not let, if you can't enhance it, then why use it to enhance other charges? There seems to me there needs to be some rhyme or reason or some parameters so that at least all the Commonwealth attorneys treat everybody equally. Because there are Commonwealth attorneys I know in this state who would never think on because I've talked to some of them and I've talked to their judges who say that they would never, if it were truly well, first of all, there's some that would never charge a burglary if it was truly a shoplifting. But the person their Commonwealth attorneys say, no, you have to charge a criminal trespass and you have to charge a theft by unlawful taking, not a burglary. But work together with the Commonwealth attorneys and the judges to take some of these things out of the PFO world. So they're all the same. But our joining county, they would never allow a PFO on a burglary that is really nothing other than a shoplifting charge that's been somehow enhanced or made to sound like a burglary because Walmart had sent them the letter saying you can't be on our property. Isn't there some way we could all work together to narrow the parameters of the PFO, when it can be used, when it can't be used, so that we don't face all of these cases? I will guarantee you today of the 80 plus cases I had, probably over 60 of them had PFOs. And the majority of them were somehow drug related. So I have a great concern, and I understand the Commonwealth's attorneys' concerns, but I have a great concern that the PFO is not doing what it was meant to do, which was to truly keep violent criminals in custody. The people that are threatening us the most, the individuals who are the gang members and the drug dealers and the people who are out there committing violent crimes and assaults. But instead it's being used for every crime imaginable, no matter how in reality how minor it is. So I'm just asking for you all to look to somehow narrow the range or the parameters to keep these other people that should never be even charged with it from being charged.
Thank you, Judge, and we hope you'll stay with us for a bit. We do have, we're going to take one thing out of order because I've been notified Schickel that he has to leave around noon, so he wanted to get a question in before he left. We're going to come back to DPA, but I wanted to make sure Senator Schickel got his question in.
Thank you, Mr. Chairman. I appreciate your indulgence. I want to ask the Commonwealth Attorney, Rob, several years we've had a bill filed. I filed it, I think the year before last, to let juries take a look at the PFO penalty. I believe it was after conviction. It's been quite a few years. I'm not really sure about the way it went down, but I was wondering if you or your colleagues ever reviewed that bill and what you thought of it.
We have, Senator, and first I want to point out the irony that, and this is part of what we consider, but the irony of what Judge Goodman is advocating for less prosecutorial discretion because she doesn't like it in her circuit when the prosecutor is not using prosecutorial discretion in the application of the PFO. That doesn't make sense to me, and that there's a reason that it came about. The late, great Ray Larson, who is a hero of mine, I think he was one of the best Commonwealth attorneys we ever had. Ray had his ways of doing things, and some I agreed with, some I don't. But the way that he came to that policy, and I believe it's a policy that they still use even after Ray's retirement in Fayette County these days. He was accused of being biased in the way that he was using his discretion on persistent felony offender indictments. So he just stopped using discretion, and he said, fine, if you think that I'm being discriminatory in how I apply the PFO law, I'm just going to apply it to everybody across the board, and everybody's going to get it no matter what the charge, no matter what your record. If you're PFO eligible, you get PFO indicted, and then you get sentenced as a PFO. And I don't agree with that approach. I understand why Ray did what he did, because he didn't like being accused of not being fair. And I believe that that policy is still in place today. And I'm a big fan of Luana Redcorn, who is the current Fayette County Commonwealth's attorney. But just know that that's how that policy came to be. But Senator, to your question, I don't think that we are in favor of what it amounts to statutory jury nullification, because it's in essence, some defense attorneys try and do that already, suggest to jurors that they don't have to follow the law. We think that people that commit the same crime and have similar or have the same criminal history should get similar punishments. And I could envision a scenario where if it's a local boy that everybody on the jury knows, they'll go, oh, well, we don't need to give him the PFO. We've all known him since he was born. But if it happens to be somebody that wanders in from out of town, and maybe they don't look like everybody in town does, or maybe they don't talk like everybody in town does, or maybe they just ain't from around here, well, then they get the PFO and they get hammered, even though both defendants committed the same crime and have the same criminal record. All of our felony punishments carry a punishment range. PFOs carry a punishment range. Juries have the choice to go high in that range or go low in that range or anywhere in the middle, and that's what we believe is fair, that people, no matter where you're from, how you look, how you sound, whether you're from around here or not, that if you have the same criminal history and you commit the same offense, you should get at least a very similar punishment, if not an identical punishment.
I know Judge Goodman wanted to weigh in on that too. So, Judge, go ahead.
Yes, what I would like to say in response to the question, and also in the comment about Ray, actually, Ray hired me as an assistant Commonwealth attorney. I've worked with Ray regularly, and also in special prosecutions. Ray started that unit at the Attorney General's office, and I was one of his first hires. I have all the respect in the world for Ray. When I ran for this position as circuit, Ray actually supported me and did my TV ads with me. But that was not how Ray and I talked about things, or what Ray's belief was, or my belief has been. So I just wanted that clear, that Ray did look at every case individually, but how Ray would handle it is it wouldn't come out of the grand jury if it shouldn't. It would be amended down and it would go back. So there are ways to do this. As to the question regarding that, here's what I will tell you, how juries are reacting in Fayette County to not knowing that what's going on with the PFO, for defense attorneys not to be able to tell them they don't have to follow it. I literally had a juror who, it was not a case in front of me, but after the juror finished serving, the juror actually called me, because I knew the individual, to tell me how appalled they were that they had not been aware of a PFO issue, because they believed the person was a drug addict. It was a burglary. They believed that the person, they didn't even want to find them guilty, but they felt they had to on the burglary. And they gave them the lesser, the lowest they could give, 5 years. And then they go in and they are told they have to do a PFO. And that jury refused. They absolutely felt they had been lied to by the Commonwealth. They believed that, and they went rogue, and they literally did not apply the PFO. To some degree, I do understand what the Commonwealth has said, and I come from being a Commonwealth attorney assistant and from being a special prosecutor across this state and prosecuting cases in 24 counties. If the jury does not believe that they're persistent, which is somewhat as a substance, is not necessary. The facts are, yeah, you committed a crime and you committed and now you've committed another felony, therefore you are a persistent felony offender. If they think that they're not really persistent, they're just a drug addict, they felt like, well, that isn't what we have here. We don't have a persistent felon, we have a drug addict. So, I mean, maybe the language of the PFO needs to be changed to that degree, that they do have a right to say, yes, factually, we see this. We see that previously they were charged with this. This crime has nothing to do with it. Therefore, we don't have to find them guilty. And so I do think that that's something that needs to be looked at. And I will tell you, jurors in Fayette County see what's going on in the world. I had a young man, I tried a case this week. It wasn't a PFO issue, but it was a convicted felon in possession of a handgun. A young 23-year-old black gentleman had gotten in a fight. Somebody dropped a gun. He picked it up and ran and begged for help. Called the police so he could turn the gun in, and the police arrested him, even though that was clearly what had happened. Charged him with convicted felon in possession of a handgun. The jury was out 7 minutes, not guilty. It's an issue. All of this is intertwined with so many other things, and we have to look at what is going on in our world and make changes to accommodate that.
All right, we're gonna yield to the DPA and let them weigh in on this. And this has been a very good discussion. We'll have questions after. I only went off the script because I wanted to make sure that Senator Schickel got his question in. So thank you both for answering. You may proceed.
Thank you, Chair Massey and Chair Westerfield and members of the Joint Committee. I'm Scott West. I'm the Deputy Public Advocate, and I will let my colleague introduce herself because she'll be speaking first about how defense attorneys view the application of the PFO statute.
Good afternoon, I guess now. My name is Ashley Graham. I am recently the directing attorney of the Covington DPA office as of 2 months ago. However, I have been practicing in Covington for approximately 11 years. If you are eligible for persistent felony offender enhancement, it is going to come into play as part of your plea offer or as part of your decision to go to trial. While Mr. Sanders says you have to do something significant in order to be charged with a felony, that's actually not the case. Residue in a crack pipe, on a baggie, on a scale is eligible to be charged as a possession of controlled substance. Giving a person's name and date of birth that is not your own to avoid detection is theft of identity. That's a 1 to 5 year sentence. That is eligible for PFO. The majority of people that we represent in court, like Judge Goodman said, and like Mr. Sanders alluded to, are people with substance abuse addictions that do get probation on possession charges. I have a number of people on my own caseload who have multiple possession charges for residue cases. They are out in treatment. But the reality is these individuals are going to miss court. They're going to be eligible for bail jumping in the first degree, which is a 1 to 5 year sentence. When they have a warrant, they're going to be afraid of going back into jail, and they're going to give someone else's identification in hopes that they may skate by that time, and they're going to get charged with theft of identity. For all of these charges, there are misdemeanors that are available. There is a wide amount of discretion that is up to the prosecutors, and some of them do wield it judiciously. I have prosecutors who have told me, prosecutors with Mr. Sanders' office, that if the hook for the felony is a flagrant non-support, they aren't bringing a PFO. I've had other prosecutors, not in Mr. Sanders' office, say that they will PFO anything and everything if they don't feel like going to trial. Jurors do have an issue with the enhancements. They don't know about that whenever they're first called to jury service. They don't know about it in guilt and innocence. I have seen jurors, whenever they hear the Commonwealth's opening statement as part of sentencing, say that this person's eligible for PFO and what that penalty range will be, they throw their heads back in surprise. We had a case in Kenton County a couple of years ago, an individual who had a low IQ. He had several fake $20 bills, which is a Class C felony, He was PFO 1. That kicked in a hard 10 sentence. The only question, to my understanding, that the jury came back during sentencing was if they had to convict of PFO. And they did. They recommended 10 years, and those jurors came back into the courtroom, some of them with tears in their eyes. I have been in jury selection with jurors who have been in trials, sentencing people, who ask to approach, and they ask if this person's eligible for PFO because they can't do that again. And they're excused. They're struck for cause. It's something that could go to the jury to give them more discretion in what they want to decide. We still have truth in sentencing as part of the penalty phase. They still hear an individual's background, the number of crimes that they've committed, what their sentences were. They would have the option to go with the minimum or to the maximum. And then the jury makes a recommendation as to sentencing. It is still up to that circuit court judge as to whether or not to follow that jury's recommendation. But when people are charged for theft of identity and their offer is 5 years to serve, we won't indict you on PFO in the first degree, which I would put forth to you, defending a theft of identity case where someone gave someone else's information is not a fun case to try to defend. That person's looking at 10 to 20 if they go to trial, and they opt to take the 5-year sentence. More often than not, this is attached with a probation violation when that sentence is going to be revoked, served consecutively, and we are filling up our prisons for people who do need social work. They need treatment. And I will say to Mr. Sanders, I believe Kenton County has done a phenomenal job of trying to get people out of custody within the first week that they're arrested. If it is a low-level drug charge, that they have a substance abuse assessment, they get out at the preliminary hearing to either go to an intensive outpatient program or to inpatient treatment. I do not want to diminish our appreciation in those efforts and great strides for our community in Kenton County. But more often than not, your first shot at treatment is not going to be your last. Our clients suffer from chronic problems of just substance abuse, of mental health, of poverty, homelessness. It is very easy for them to get charged with low-level felonies just by virtue of their status in our society. And I think that in order to, with the PFO, our sentences keep getting longer. We spend more money incarcerating people. Probation and parole could take some of that money to hire more officers to supervise people in the community, to connect them with services, to help them find employment, to help them find housing. And it's just very unfair to the people who they get so many charges because they are more often than not a lot of low-level crimes that they just keep getting churned in and out of the jails, and they violate probation, and there's a lot of lack of services. But I will turn it over to Mr. West, and thank you for the opportunity to speak.
Thank you, Ashley. I want to tell you two stories from my tenure as being a public defender. One of them was I had a person who had a really good defense. He was charged with second-degree assault. The issue was the extent of the injury. If it was a serious physical injury, it was 5 to 10. If it was not a serious physical injury, then it was a misdemeanor. And I thought we had a great case. The victim had gone to the ER room, had been triaged into the lowest level because they didn't see a serious physical injury. And I thought that the medical documentation supported that. The problem was he was first-degree PFO. And if he lost and didn't take the 5 or 6 year offer, then he would have to go and do 10 to 20. And then he would have to do, because it was a first-degree PFO on a C, he'd have to do 10 flat. I do need to correct something in the paper that I supplied you all, and I have Rob to thank for that. I put in on page 3 that it was 10 calendar years. It's not. It's 10 state years. So you do get good time, meritorious good time, and you can reduce the 10 calendar years to a lesser period of time. So I apologize for that. It should say 10 state years, not calendar years. But he couldn't take the chance. And so we didn't get to go to a jury with our story of what happened in this fist fight. He took the 5 or 6 years and left what I thought was a good defense on the table. But I go at home at night. I'm not the one that has to do the time. Another story I'll tell you is after I'd lost a case, a juror came up to me afterwards in tears. She said, "I'm not sorry that we convicted your client, but I am sorry we had to give him that much time. We didn't want to, but we felt like we had no choice." And I said, the only thing I could say is, well, you don't need to apologize. You did what you were instructed to do under the law. So that's all I could tell her. But she was upset that they had to give so much time to someone. Because the way that the PFO law works now, it reads the word persistent right out of the title. When people hear persistent, they think of what we all think of when we use the word persistent, time and time and time again. But it isn't time and time again. It's just the very next time is where it can start. I've given you proposals. I know it's 5 pages worth. I'm not going to go through them. The whole reason I wrote them down was so that you all could have them and look at them on your own time. But I do want to talk about the first page. The crown jewel, I'll call it, of our proposals is the jury empowerment proposal. Just by changing the word shall to may, the jury can decide what this case under these facts is worth. The legislature sets the range of penalty, but it is the jury that applies those facts to the law and says, we think this person should be sentenced at the lower end or the higher end or somewhere in the middle. And what this would do would give the jury options. If they are angry at the person, they hear his record, they see how many felonies he's had in the past or she's had in the past, they can hammer that defendant as hard as they ever could. That's not taken away from them at all. They can max the person and run it consecutive. We call that max and stack. And I've had juries mad they couldn't max and stack more. But if they find a measure of mercy, if they think that this person is going to be penalized too heavily, then they can sentence at the lower range of the penalty before PFO. And it's the jury's choice. And that's how you know what a case is worth wherever you are. It may not, the same set of facts may get you a different result in Pike County than it gets you in Paducah. It just might. But it's the jury that's the marketplace to set the value of what crimes are worth in that community. And this returns to them the ability to decide what the case is worth, but it also impacts negotiations. You have people who really want to go to trial and they want to exercise their day in court, but they're afraid to because the penalty has just doubled or in some instances tripled. And so what this would do if the jury empowerment was passed, then there's going to be a real conversation about what the case is worth. It's no longer the prosecution's guaranteed a minimum that they would be happy with. They have to look and see if they get the minimum on the underlying charge, and that will impact the negotiations. Because what you're looking at is what will a jury do. Some of the other proposals, I only talk about the other two on the first page, return to the original PFO law. Back in the beginning, it used to be that you had to have 2 felonies and you had to have served time in prison twice. That was the minimum for finding someone to be a persistent felony offender. Over the years, it's become with just 1 felony, and then you don't even have to serve any kind of jail time. If we return back to the original PFO law, that would be an improvement. And then exempt Class D felonies. That is the lowest level of felony we have in Kentucky. Make it so that they can't be used to PFO something or be used, either be used to PFO another crime or be used by another crime to have a PFO sentence. We have other suggestions, and these are not meant to be, please do all of these. Well, I mean, I guess in my wildest dreams, as a defense attorney, I'd say please do all of these. But this is really presented as a smorgasbord. Some, one, multiple, that would be up to whatever consensus can be gathered at the General Assembly. I will say this, that when Senator Schickel talked about the jury empowerment bill, that was the first proposal he was referring. We asked him right before COVID struck to carry that bill for us. And he was agreeable because he agrees that juries should have a bigger say in their community about what a crime is worth. And they say be careful what you ask for, you might get it. I get that. There may be somebody, they say, well, we know this guy. We're not going to hammer him. Whereas a stranger in town, they hammer them more. But I don't think you fix that by making the law so that you have to hammer everybody. That's how we'll make it equal. Nobody gets mercy. We'll hammer everybody as hard as we can. this at least gives both sides the ability to make their case in front of a jury, and that's what we went to law school to do, is to have a even playing field and talking to the jury about what the case is worth. I thank you all for your time listening to me, and that concludes what I have to say.
As expected, thank you. As expected, I knew we would have a few questions, so we'll start with Senator Turner.
Thank you, Mr. Chairman. I appreciate everybody's been here. First, I got to make a little bit of statement with your permission, sir.
Proceed.
As 42 years of practicing lawyer and watched a Commonwealth attorney grow from one person and a secretary to, I think they've got probably 8 working in their office now. We've got 3 or 4 people that's watching people that are criminals. We've passed statutes that says if you give a false ID, you're going to be charged with a felony, just like you've said. I've seen it. And now about 5 out of 20 people get charged. They've given a wrong ID, they say, no, I didn't. It's always a question, but they've got a prior felony, a simple felony. So, and I don't think any legislative laws we pass are jokes, but I think there's a problem with the legislative laws we pass because we're not treating everybody equal in this state. When you give Commonwealth attorneys discretion in each county, you're getting treated differently in each county. So we as legislators should undertake now to take some of the things you just said, turn it over to the hands of the jurors. They're treating everybody the same in this state. So, and I think the judge, good honorable judge, should have, when she heard those facts, just granted a judgment saying there's no intent to possess a gun, and that should never went to a jury, but that's just my opinion. So I guess a question I have for the DPA side of it from both of you all, other than these things that you've passed on to us to look at, is there any other thoughts? I've heard this young man's statement. I've represented many people that's been in prison, done it all in 42 years. Is there anything else we need to do besides work on the Pfo law, which I plan on helping undertake with these gentlemen and ladies that are seated here to try to do to make it the same throughout the whole state?
I think that there is. I mean, the Pfo area of the law is one area, but I can think of others where uniformity could be brought across the state in a lot of places. I always am worried that I'm saying get rid of someone's discretion, but I think that the more you get up in a higher penalty, the more liberty you're taking from someone, the more boxes should have to be checked before the state deprives someone of that liberty. And so there are other areas of Pfo. Mr. Sanders said that he didn't want to get on his soapbox about violent crime. I have a soapbox too. And that's something that we could talk about and probably disagree on 80% of it, but we can usually find a 20% where we agree. But I would think violent crimes and how we approach violent crimes and the effect on violent crimes is another area other than Pfo where we could do something across the state in that regard. I did give a copy to Mr. Sanders. I'm not a hide-the-ball type person, and if we come up with any kind of provisions, I'll give those to him as well, and we can have those for discussion.
Just one more thing. I appreciate that, and would you agree to provide those to the body here also?
Once they're drafted, yes. Everything that I would draft in the way of a legislative proposal, I would present to the entire bodies.
And one other statement, Mr. Chairman. I would hope everybody would look at that case where it's in the Supreme Court's not too long ago opinions, if you get the law summary, that talks about a person, I think they were charged with a little drug charge, and it was a Pfo, went to trial, and the Supreme Court cites where the Commonwealth attorney was overheard on tape telling a detective to lie. I'm keeping an eye on that. I hope everybody in the system is to see what happens with that. And we'll see if he gets prosecuted like that poor little person that you represent and I represent and everybody else represents sometime. Thank you, Mr. Chairman.
Thank you. Representative Petrie.
Thank you, Mr. Chairman. Pfo, it's complicated. If you read the statute, it's complicated. And if you're not an attorney practicing in the area regularly, it's very complicated. You can boil it down in some senses, though. The General Assembly should be looking at a matter of justice. not giving or taking away discretion, or protecting a defendant, or protecting the prosecution, or protecting a judge. Each of those three parties are going to have a certain amount of discretion in every single case that comes through the criminal justice system. Now, with that said, sometimes our system gets out of kilter, and our scales of justice are tipped oddly. Or you could even go so far as to say in certain jurisdictions where a prosecutor is not applying discretion to PFO charges, and it is a carte blanche policy, then that policy is actually a battle axe they take to every negotiation. Very much out of kilter. Now, you've got to be very careful. Complicated system, you pull a little on one thread, and there's a whole lot of framework that comes apart. There's three ways I think you can look at it, and I think they've all been covered, but I'm just going to try to boil it down and make sure when I'm wrong, somebody can tell me that. You can look at the scope of applicability of the statutes. To whom is it applying? To what cases? To what charges? To what level of offenses? What time frame it's? And you can work on those type things. You can also look at the discretion of a judge in the sentencing on a PFO conviction, whether there be probation or some other way to dispense or dispose of that sentencing option. And then there's another one which you've mentioned and Senator Shekels mentioned. I think I may have filed a bill also on this at one point in time, where you change and give the jury discretion to say, no, we're not going to apply the PFO. Just to make sure everybody's clear, if there is an underlying applicable charge in the past and a set of court records are pulled up and it's proven, yep, that happened, and yep, this fits within the statutory framework, if the jury finds those facts to be true, that PFO is stuck. And they have no discretion whatsoever unless somebody said they go rogue and they go against the instructions that a judge gives them. And I don't want them to do that. I think that the instructions ought to be given, but that the jury ought to have discretion at a minimum. When you go to look at the applicability and tinkering with the mechanics, it's going to be a dogfight in this General Assembly and outside of this General Assembly and everybody involved, and there's ground to work there. Discretion for the judge may be a little easier to deal with. We have to trust our judge's discretion. We've got better and worse ones like in any profession, but our system demands that they have a certain amount of pressure relief valve when they see something go so horribly awry. In fact, even though it may fit in law, there's an ultimate pressure valve to be released, and the judge may need more of that. But I think at a bare minimum, when you look at the PFO, and I'm not really concerned about how many people are incarcerated. I'm not really concerned from a policy standpoint of how much money we spend on that. I'm concerned because we watch it all the time and it grows all the time. But if somebody's committed a crime, especially a predatory crime, they need to be in jail for multiple purposes, multiple ends. However, when that system gets out of whack, when it gets out of kilter, we have to do something. There is nothing wrong with giving a jury that finds guilt on the facts, giving them the same discretion in each jury that's called in every part of this Commonwealth, the same discretion to say no to a PFO that they think in that community doesn't fit. And I've said this, and I'm glad to hear it repeated today. A jury in each jurisdiction is the final arbiter of what every crime is appropriately punished. And every county and every jury is going to be a little different, but they're basic trends. But giving power to a jury, discretion to say no, is even a better pressure valve, I would submit, than giving that discretion to a judge, because it is the community that has to feel the before and after effects of each criminal offense is the one that ought to be making that determination. I'll be glad to support that portion of any bill that comes through as long as we've got good language on it. I think the bill that I had changed one word from shall to may. I still stand fully behind that bill. Thank you, Mr. Chairman.
Thank you. And we have one last question. We're going to move quickly so we can get to the other matter, but Senator Berg.
Thank you, Mr. Chairman. I actually have two questions. Sorry. Just because I really, not a lawyer, don't know this, possession of marijuana to get a D felony conviction, how much does it take?
At least 8 ounces and evidence of trafficking.
So 8 ounces,
A half pound. Yes,
half
ma'am.
a pound of marijuana, and that you gave it to somebody or you sold it to somebody.
Or that it was intended to be trafficked. Yes,
That it
ma'am.
was intended. Okay. Do we have, may I proceed? Thank you, sir. Do we have any data in the state, and we may not, looking at when these PFOs are applied or are not applied based on race or ethnicity?
No, ma'am. And that's one of the things in Chairman Massey's committee that he called to discuss possible changes to the PFO. That was the very first thing I brought up, and that I know the judges that were involved in the panel agreed with, is that Kentucky is horrible at data collection. And it's not as easy as you might think to collect the data on PFO, because you not only have to collect the data on who gets a PFO, but you have to collect data on who was eligible for PFO but did not get a PFO. So I know that it is more complicated than just saying, no, we don't collect the data. It costs money. You have to pay people to do it. You have to develop the computer systems to track, and somebody has to take on that burden of tracking it. But that's one of the things I would really encourage the legislature to do, is invest in the data collection so that we know exactly where the problems are. Because right now we've got people throwing out stories of individual experiences of this one case then, or this one case I had, or this one case I heard about. But we really don't have data on any of it. And no one has been tasked with collecting it, with very few exceptions, and no one has been funded to collect that data either.
And the other reality is there are threatened PFOs that are never filed but play just as real a part in the settlement negotiations. If someone says, and they have said, if you don't take the offer and you take this to trial, we will PFO you. And then you have the option, and you have to the duty to look and see if it's an idle threat or a real threat. But once you determine it's a real threat, you've got to go back to your client and say, they've said they will PFO you. They do have the ability to do it. Do you want to take this offer or not? And if they do, there's no data there that ever shows that PFO entered the system, but it was just as real. And just one other anecdote, someone said, if you can work this in, try to work it in. There was a person charged with kidnapping, first-degree burglary, and strangulation. They took it to trial. It was PFO. They won. They got an acquittal on everything. They simply did not believe the story. But while they were in jail, they picked up a contraband charge. The offer was 1 year. After the acquittal, the offer was PFO'd and went up tremendously because they were wanting to get back what they had lost at the acquittal. And those are some of the ways that in the discretion, it wasn't a PFOable charge, but after this win, okay, well, we'll get it this way. Those things happen, and I get flooded sometimes with conversation. People come up and say, yeah, let me tell you about what happened to my client.
I want to thank everyone today. I'm not trying to cut anybody off. We do got another section we got to get on. We are going to continue this work group through the year. Certainly, if any members of this panel want to be involved in that, that's fine. I know Representative Decker had a question. She might want to be in part of that. We'll certainly take that. Judge Goodman, thank you for being here today, and all of you for presenting. It was a very good discussion, and we'll continue to work this, and we'll see where it turns out. So thank you.
Mr. Chairman, all I would
you.
encourage is for all the legislators here, if you have a question about some of the nuanced stuff we were talking today about theft of identity or about residue cases and things like that, and you want to know why certain things are treated certain way, I would encourage you to reach out to me or another Commonwealth attorney and ask them why those things are, because we just don't have enough time to explain all the nuances of what we're talking about. But there is a rhyme and a reason to the way we do things, and I would encourage you to reach out and get an explanation if you do have a question.
Thank you to all the presenters, and I'll be reaching out to you. Thank you, Judge.
Thank you very much.
All right, we're going to move right on to exoneration compensation. We have Suzanne Hopf, Lori Roberts, Janetta Carr, and Mike Von Allman. And I don't want to shortchange anyone, so we're going to keep moving quickly to get you up here. And I know that you have your presentation ready to go, so we are going to turn it over to you, and you can proceed when you are ready. one of your people on Zoom as well, because we have somebody on, we're not sure.
We should have Rebecca Brown should be joining us from New York with the National Innocence Project.
Okay. Is that what it is? That, we do have her, so she's here.
And are we good?
All right.
Share screen. That's good right here. Okay. And then where's Maximize?
Oh, I think actually you want to share the PowerPoint version.
There we go. Members of the Joint Judiciary Committee and Chair Massey, Chair Westerfield, thank you very much for giving us the opportunity to come and talk to you today about something that Kentucky has not considered and has not brought forward for legislation, and that would be wrongful conviction compensation, and a bill that would allow Kentucky to start compensating some of the past exonerees in Kentucky and what we hope to be some of the Kentucky's future exonerees. It's an honor to be able to speak to you on behalf of Kentucky's exonerees and the men and women who have had their liberty interests curtailed through wrongful convictions in Kentucky. I have with me one of Kentucky's most recent exonerees, and that's Janetta Carr sitting with me, and also one of Kentucky's longest-standing exonerees, Mike Von Allman. And they'll be talking to you shortly about not only their experience and their wrongful conviction, but also the experience and the difficulties they had reintegrating into the community after they were exonerated. And so we're not here today to talk about actually the reasons for wrongful convictions, although I think it helps create a context for what's occurring in Kentucky, but actually to address what's happening when people are exonerated and have been found to be factually innocent of the crimes that they spent many years in prison serving on. So very quickly, I just want to point out that there have been 38 states that have passed wrongful conviction compensation bills, as well as 2 other jurisdictions, the federal government and D.C. So Kentucky really lags behind as far as compensation and legislation that would allow exonerees to get a foothold when they return to the community. The Innocence Project in New York handles many, many DNA claims across the country, and their statistics show that the average DNA claimant is in prison for 9 years before they're exonerated. And the National Registry of Exonerations is a database that searches all media and all court files to understand the reasons and the factual situations and the procedural issues in wrongful convictions. And their data shows that the average person who is not on a DNA claim, who has been in prison because of a non-DNA claim, serves about 14 years in prison. So what we'd like to do is tell you the stories behind Janetta Carr and and Mike Von Allman and their experiences, and then we'd also like to discuss what are the components of a successful wrongful compensation bill, and what should Kentucky be looking at. So with that, I'd like to turn to Mr. Von Allman and have him talk to you about his experience and what it was like to try to return to the community with a felony conviction.
Push the button there.
Okay.
There you go. Now we can hear you.
Mr. Chairman, other members of the committee, thank you for this opportunity. First off, I would like to start off with a couple pieces of identification. One is my Kentucky driver's license. Born in Louisville, raised in Louisville. I hope to take my last breath in Louisville. Other piece of identification I have is a Kentucky State plumbing license. This is how I've earned an income in Kentucky. Another document I have here is a Social Security earnings statement, and it's recorded every dollar I've made my entire life. It'll show you, one, that a plumber's wages are pretty decent, that I've been successful, that I've maintained a mortgage payment and 2 car payments, married the same woman, married the same woman I was with beforehand, successful by most measures. The other thing I want to show you with this document is that your Social Security benefit is based on the numbers that you put here. The 11 consecutive zeros on my statement clearly shows that the harm from a wrongful conviction lasts my entire life, the span of everyone's life who was wrongfully convicted. And since I'm a plumber, if I can get you all to stay with me quickly on a quick plumbing history. Plumbing originally began with a simple design, a pipe to carry water into a fixture, another pipe to carry the wastewater away. We grew, our buildings got bigger, our plumbing systems got bigger, but the design was still the same. Water in, water out. Back in the 70s, they came out with a product that you hung in the back of your toilet, dumped a bunch of blue chemicals into your toilet, and cleaned your toilet automatically. Wasn't long after that product came out, people started getting blue water at their kitchen sinks. And what they were finding was that under ideal conditions, that water out of the back of the tank was being siphoned back into the public water system. I'm sorry. This problem was quickly identified, and governing bodies conceded the problem and came up with remedies to reduce the occurrence of these plumbing perfect storms. And from what this plumber knows about tort law, there were layers of protection for the people who drank the blue water and were harmed, either through the plumber, through the building owner, or through the water company. Somebody was held accountable for that harm. It was 1988, and I was locked up at the reformatory in LaGrange when I read a Courier Journal article about a case in England where they took samples from the entire town trying to find a child killer using this new technology called DNA. I jumped on this technology right away, trying to use it in my case, only to be told that my evidence had been discarded already. But DNA continued to develop, and legislature, and it started exposing monumental perfect storms in the criminal justice system. Legislatures across the country have since been adjusting their statutes over DNA technology, and this very meeting today can be traced back to DNA. My perfect storm started when, can you show the tacket? If you don't mind, go to the other one, we'll come back. My perfect storm started when that guy on the right went into a bar in South Louisville where he abducted a young lady, took her to a local park where he raped her, robbed her, and sodomized her. The victim knew this guy was checking her out and was able to make a very good composite drawing of the guy, if you don't mind. That drawing was certain. The assault occurred on Friday night. Saturday night, that picture was circulated. And then on Sunday night, if you don't mind going back to the other one, that's me on the right. On Sunday night, I went to the very same bar without a clue what was going on in my world. The owner of the bar, looking at that composite drawing, jumped in his car and followed me home. The description had him as driving an old green car. I had a blue Volkswagen, but I lived in a pretty good sized apartment complex, and when I pulled in and parked next to my neighbor's green 68 Chevrolet, he called the police with those two license numbers. A photo pack was made with one big curly-headed guy in it. When the victim got to the one big curly-headed guy, she made an ID. I was arrested. A year and a half later, I went to trial with somebody covering every minute of my night. But the brutality of her assault trumped everything and every word any of my witnesses said. I was convicted, sentenced to 30 years in prison, and started the fight of my life trying to prove my innocence. Eventually, I was able to get up to the Louisville Police Department and take a polygraph test with them, and that got my case reopened with another suspect in mind. The other suspect never yielded anything significant to help me get out of prison, but it was enough that the parole board became aware of it. And at my fourth meeting with the parole board and 11 years in prison, they gave me the benefit of the doubt. They had that discretion back then. They don't now. Statutorily, they can't. I got out on parole, right away realized I needed to make some kind of career decision, and plumbing was it. I did well as a plumber, stayed on parole for 16 years when my reverse perfect storm started, and that's when the state of Kentucky got one of 5 grants from the Justice Department to investigate wrongful convictions. I called the Kentucky Innocence Project right away, and the other part of my perfect storm was Ted Schaus, the attorney, and the investigator, Gary Simpkins. Luckily, Gary Simpkins had just retired from the Louisville Police Department. He knew all of those officers that I was talking about. He had worked for decades with those guys. The police department gave him access to their records. They were able, in no time, locate this guy from the grave. He was killed 2 months in a car wreck after I was convicted. But they were able to find him and pull out his priors. We presented it to the courts, and they didn't hesitate. My case was dismissed after 27 years as a convicted sex offender. And I'll yield from there.
So I'd like Janetta Carr, she's one of the most recent exonerees in Kentucky, to also tell you about her story.
Hello. Can you all hear me okay? Hello. Thank you for allowing us to be here today. My name is Janetta Carr. I am an exoneree and a citizen of Kentucky. On January 6, 2006, at 16 years old, I was taken into an interrogation room, left for 11 and a half hours, denied access to my mother, denied access to an attorney, verbally abused, coerced in an attempt to make a false confession for a crime that I did not commit or have anything to do with, all the while maintaining my innocence. On that day, my dreams of becoming a paralegal quickly turned into a nightmare. From the interrogation room, I was booked in JCYC, where I sat innocently awaiting trial with laid over court dates until the age of 18, at which point I was transferred to the adult jail. At 19 years old, I was approached with an Alford plea or the possibility of the death penalty. Due to pressure of facing death innocently and with the understanding that by accepting this plea, I would still be maintaining my innocence, I signed the plea. In December 2009, I was released on parole. Thinking the nightmare was over, trying to navigate my new life as an innocent person released became a battle of its own. Finding a livable paying wage job with felonies on my record, being forced to report and pay supervision fees for 9 more years of my life, knowing my freedom could again be innocently taken away at any moment, along with the lost time I missed with my family and friends and starting my career, became a mental prison. Trying to understand the how and why with no resources, being an innocent convict. With the help of my family, friends, and God as my strength, the battle became a journey. In 2013, the Kentucky Innocence Project started investigating my innocence. And in December 2019, I received a pardon and became exonerated. I am the youngest female exoneree in America, and I am the youngest exoneree in Kentucky at the moment. As I have shared my experience with you as a wrongfully convicted citizen of this Commonwealth, I am only one of many citizens who has had to experience such a terrible miscarriage of justice. According to the National Registry of Exonerations, there are a total of 23 cases from Kentucky, where it is estimated that at this very moment, at least 1,600 citizens of this Commonwealth still are confined in jails and prisons all over Kentucky innocently. Each exoneree has our own experience, but the one thing we have in common is the lack of resources upon our release as wrongly convicted citizens. Today, I come to you with a call of action for Kentucky. Now is the time for Kentucky to do something about wrongful convictions. I'm 33 years old now, and I'm also a mother. I have a 9-month-old daughter, and I have a 5-year-old son. The worst thing that comes to my mind is my son possibly having to go through and deal with what I had to deal with. I do not want Kentucky to be left behind in the fight to get these underlying issues corrected, wrongful convictions, and I know that we can do it. Thank you for your time.
So what we'd like to propose is model legislation that we've provided in your packets. It's also available at the LRC website. And the important issue here is not just to pass a bill, but to pass the right bill. That the bill has to have certain key components, otherwise it's not going to allow the exonerees to actually access the funds that they need to rebuild their lives when they're released from prison. So those 4 key aspects, those 4 key elements that are critical is to provide at least $50,000 of compensation per year when an individual is wrongly convicted. In addition to that, there's several other provisions that are helpful, such as additional monies when an individual is sentenced and spends time on death row, or a lot of other states also provide an additional $25,000 for people like Janetta or like Mike who were on parole for a period of time because of the difficulties that they encounter while they're on parole. So that's provision number 1, is a minimum of $50,000 per year. There also needs to be a reasonable standard of proof for eligibility. Most states find that the most reasonable and what makes the compensation funds accessible for exonerees is a standard of proof of preponderance of evidence. Those states that have had a higher standard, such as clear and convincing, have had to rewrite their statutes so that the funds are actually accessible by the exonerees. So the suggested standard of proof is preponderance of evidence. The third provision is that it is a straightforward process for courts to adjudicate claims. Some states allow compensation boards or other committees to make the adjudication and the determination whether somebody is eligible for compensation. The problem with having a commission or an additional committee is that those individuals are not necessarily trained and have everyday dealings with a due process type of a system or standards of proof or developing factual evidence. The majority of states have courts, I think it's 22 states in the United States, have courts that are making this determination, and the remaining states have some sort of a committee or a commission or another adjudicating body. But the recommendation from the Innocence Project and from the Kentucky Innocence Project is that the courts adjudicate the claims because they're trained on adjudication and developing factual evidence. And the fourth provision helps to assure that the citizens' taxpayers are protected, and that is that there is some sort of an offset provision in case there is a future civil judgment because of malfeasance or malpractice or unreasonableness on the part of the local law enforcement or the prosecutors. And that offset then allows that any kind of compensation that was received by the individual through wrongful conviction compensation law, that compensation then is paid back to the state if there's a civil judgment against a specific entity. We do want to say that many states, and we've in your handouts, we've broken down what states have what kinds of provisions. Many states have additional supplemental awards for individuals who spend time on death row, and the majority of states award $25,000 for those individuals that are either on parole, on the sex offender registry, or are placed on probation. We also want to point out that many of these exonerees spend in excess of 20 years in prison. And what comes to mind are several recent exonerees. Jeff Clark and Gar Harden spent 22 years in prison before they were released. Another very tragic story that's on slide 2 of the presentation is the case of William Virgil. He spent 28 years in prison. He was released. He was exonerated. He fought to and filed civil suits in federal courts for compensation, and sadly, his life was lost. He passed away after 28 years in prison, almost 5 years to the day after being exonerated, without getting a single penny of compensation. And that's because he had to fight in federal court in a long, drawn-out process. It's still ongoing. The money will go to his estate, but William Virgil never saw a penny of it. If Kentucky had had a wrongful conviction compensation statute at that time, he would have been able to file and receive at least a small amount of compensation for those few 5 years that he was able to be released and be back in the community. So what we've done in the handout is we've provided model legislation that does hit all of these key targets. Those 4 main provisions, those are sort of like the main pieces. A tangential piece is also making sure that there's a social services safety net when people are released from prison. And that's because, and you can imagine with 20 years in prison, you may have not had the best of medical care. You may have not had the best of dental care. You don't have job skills. You don't have a track history of employment. You don't have housing set up. And I want to drive home the reality of what happens to exonerees. Jeff Clark, Gar Harden, they were in their 20s when they were convicted, and they were released in their 40s. But we have another exoneree, an example, William Virgil, as well as Norman Graham. These were older individuals. They were released in their 60s and their 70s. Their health is very fragile. What's even worse, they don't have the family support that somebody who's leaving maybe in their 20s or their 30s or their 40s would have. When somebody spends 20 or 30 years in prison before they're released, many of the people that they have those strong social ties to, those social connections, the family members, the aunts, the uncles, the mothers, the fathers, those people that could provide support, they're gone. They've passed away. They've lost those family members while they're in prison. On the other hand, the younger individuals, the sons, the cousins, or the nephews, they may have been so young when they went off to prison that they didn't have a connection. They didn't have a relationship with those relatives. So it's very, very critical to put some sort of a safety net in place. In addition to that, tuition assistance, and I think Jeanette's story really drives that home. This was a young lady who was going to paralegal school. She was enrolled at Sullivan University. She was going to go and work for the prosecutor's office. She wanted to fly on the white wings of justice. And by the time she came out, she understood she was no longer aligned with the prosecutorial side of the criminal justice system. And instead, she had completely derailed her ability to gain that foothold in her late teens, early 20s, and get her education and become employed. She doesn't have a driver's license because she lost those years. 16 years old, she should have been learning how to drive. She should have been spending time with her friends. She should have been doing internships or externships, going into the field of employment, developing a career, and instead she was waiting in prison. Fortunately, Janetta was released and she had family members that she could rely upon. That's why she's here today. But we have other exonerees who are released in their early and late 60s who have tremendous health problems. So they need medical support, they need tuition support, they need support with housing, they need assistance, job assistance, finding employment, so that they can become tax contributing citizens to Kentucky. So actually, right now, what I'd like to do is yield over to Rebecca Brown. She's the policy analyst for the Innocence Project. She's based out of New York. She has helped other states develop legislation that puts those parameters in place, those 4 key elements, and allows for accessible compensation bills for our exonerees.
Thank you, Suzanne, and good afternoon to the committee. It's an honor to be with you today, and I'll just speak very, very briefly because I know that you have other business to get to. I am the Rebecca Brown, Director of Policy with the Innocence Project. We're a national organization, and we work in partnership with innocence organizations like the Kentucky Innocence Project around the country to try to pass robust compensation laws that will benefit the wrongfully convicted. And the only points that I really wanted to make today were just, I think that there is nothing that compares to the unique horror of a wrongful conviction. And when people come out, so often they have nothing. They've had years stolen from them. They've lost the opportunity to, build relationships. Family members have died. And they just haven't been able to develop professionally. And so, we heard from both Mike and Janetta, who are exceptional people and were really able to get their lives moving again, but not without a lot of help and support. And certainly there are many people who don't even have that. And so, this is just a profound need that the wrongfully convicted deserve. I do want to address one issue, which is that folks oftentimes believe that civil settlements are common for the wrongfully convicted. They are not. It's very difficult to prove to really receive compensation under a civil settlement, because you have to prove first that official misconduct took place and then that it led to a constitutional violation. They're very hard bars to reach. Some exonerated folks have been able to do that. And you heard from Suzanne that, you can deal with the potential of a double recovery, which is oftentimes a concern of various states, with an offset provision. But I did just want to note that the civil settlement is not available to the lion's share of exonerated people. So it's that much more important that a global compensation framework be in place so that, all actually innocent people can be compensated for their wrongful convictions. And the only other thing I would add is we worked most recently in Indiana, Idaho, and Oregon to pass compensation laws. All of them have preponderance of the evidence standards in those proposals. And I just offer that to say that we are happy to be a national resource to you. We've worked on these bills throughout the country. We are very aware of a lot of the concerns that people have and have been able to work through those concerns in various states. And just want to offer myself to the committee and the legislature in general, just for, as a resource as you pursue this. And we're very, very grateful that you're considering this. So thank you so much.
I want to thank all of you for this presentation. I do want to tell you that I did get a text from Representative Nemes that said he did file a bill last year, and I do believe he intends to file a bill this year. He's listening to us. He's actually in the Bullock County Circuit Court waiting to be called. So I don't know as an attorney, not as a defendant, as far as I know. But in that regard, I think he's very interested in pursuing something along the lines of that in the coming session. So obviously, this is something that we met in my office before and talked about this, and I'd heard the stories of these wonderful people, and I can't imagine of losing not only the time, but losing that time away from your families, your children, those that you love. And obviously it's not a perfect system. We still believe it's the best in the world, just not a perfect system. And so, but for those people that have undergone that, unfortunately, they do need the wherewithal once they are released. I mean, we're making strides right now, I think, through some legislation to help people like Representative Mosier's bill that will allow them to get an ID and allow them to try to get some work assistance and things when they're released. but that's in cases where the person has been convicted, not necessarily where a case where there's been an exoneration. So I want to thank you for bringing that. I do want to open this up for questions quickly, but and we do have a couple. So Representative Bratcher.
I don't know if you mentioned this, but how many average per year, say in Kentucky?
According to the Innocence Project, our own statistics, as well as the National Registry of Exonerations, there's approximately 1.25 exonerations in Kentucky per year. Those are what I would call official exonerations. They are vetted by us. They're something that we've followed and initiated, as well as the National Registry of Exonerations. They go through the court documents, the news reports. They do investigative journalism to develop. So our statistics show about 1.25 exonerations per year.
And how many would be? This is retro, right?
We would make it retroactive. Moving forward, there would be a 2-year statute of limitations for filing. The model bill that we proposed anticipates filing something in a circuit court. So once you are exonerated, you would have 2 years to file something. And then that court makes a finding as to whether you are factually innocent or not. And that controls whether you access the compensation funds.
So how many are in retro?
I think we've got 4 exonerees that have received compensation. So that would leave about 19 exonerees that have not. Although some of them, I think 5 of those exonerees have ongoing civil suits through the Exoneration Project currently. And then, of course, if those individuals, and these take a tremendous amount of time. I know that the civil suits that have been filed have been in litigation for at least 3, if not 4 years. So the concept here would be if it has potential that these individuals who have current civil suits, that they could access this funding, even if it took a year to pass it and another 6 months to implement the bill. They could potentially access this funding before their civil suits are settled. They just take a tremendous amount of time, and that's William Virgil's story. Is 5 years out, almost 5 years to the day he passes away, and he still hasn't seen a penny.
Don't get me started on the length that these trials take, because I'm a big critic of it. It's ridiculous to be 4 years. What in the world are they looking for? Don't answer that. This is rhetorical. I'm moving on. Thank you, Mr. Chair.
Thank you all very much for your presentation today. I know it's difficult, especially for those exonerees, to come here, and I'm sure they're glad to tell their story, but I'm sure it's difficult as well, as you indicated. So thank you for being here today. For the benefit of the IJC, the next meeting will be Thursday, July 7th, where the Honorable Guru of Justice, Chairman Westerfield, will preside, and then I will be here as well.